Fantastic. Well, welcome everybody to today's webinar, in which we'll be talking about contract red flags. I'm Alex. I am the co-founder of Sprintlaw. Before we get into the kind of educational content for today, just to quickly introduce our business to those that are not already clients. We're an online law firm really designed to help startups and small businesses access affordable legal services. Most of what we do is fixed fee legal services. If you need advice on pretty much in any area of commercial law, from business setup to contract drafting to intellectual property, data privacy, employment, we can provide you with some lawyers that can help. We also have an optional membership that about 90% of our customers end up signing up to. We've actually recently just had a massive upgrade to our member platform, and I actually might just give everyone a quick 1 minute look at it, just because I'm particularly excited about it right now. We've been doing a bunch of press all week for it. So for anyone interested in checking this out, you can hop onto our website, sprintlaw.com.au/platform, and just make a free account. And once you're in, there's a ton of features. This is the paid version, although in a moment we do have an offer this month for Black Friday that makes it fairly cheap to upgrade. But you get access to be able to create a ton of free legal documents. You can, if you're a paid member, book unlimited quick calls with our lawyers, use our e-signature tool, stay on up to date with upcoming webinars like these, monitor your legal health, and we've got an AI tool as well, which you can chat to using voice chat or upload a document for a free review and more. So for those that aren't aware of this, encourage you all to check it out. It's pretty cool, and it's kind of hot off the press. So a bit more about us. Bit over 6,000 clients, lots of positive 5-star reviews, a team of over 50 staff, and we're originally from Australia, but now also expanded to the UK and New Zealand as well. And this is what I mentioned earlier. For this month, we're doing a big discount on our member platform subscription, the thing I just kind of demoed for 1 minute there. It's usually $800 a year, but it's down to $399 for 12 months. So that's a single payment of $399 for the whole 12 months. For those interested, definitely consider signing up. You actually get $250 to use on legal services each quarter. So it can really pay for itself if there's just 1 or 2 items that you need help with. So let's get into the subject of today's presentation, which is contract red flags. And really what I'm going to be trying to do is start from the absolute basics, like what is a contract, why do you need to get it in writing? And then I'll be going through some concepts in terms of how to understand and read contracts, and then really diving into some specific clauses that you'll commonly see in many contracts around payment, scope, IP, termination, liability, and explaining, what you might look out for if you are given a contract with some of these clauses, and where the red flags may be. If anyone has questions as I'm going through, please use the Q&A and chat feature. And I'll try and keep an eye on it as I'm going through. I like to answer questions while I'm on the topic if I can. So no need to save them for the end. Although if there's too many, we may cover them off right at the end. So let's start with the very basic question: what is a contract? Well, what they teach us in law school is that a contract has 4 elements. It is an arrangement that has some form of offer, then some form of acceptance of that offer by another party, an element of consideration, which is a kind of weird legal term that really means, somebody is paying something in exchange for something or giving something in exchange for something. It needs to be an exchange of value of some sort. So it's not necessarily just a gift. And finally, there has to be an intention to create legal relations. So it's not a casual arrangement, but there is some intention to create, a binding arrangement there. There's a few other technical factors, like, they need to have capacity, they need to be of sound mind, et cetera, et cetera. But these are really the 4 core elements to what a contract is. And you'll notice in there is nothing that says needs to be in writing. It is possible to have a contract that's an oral arrangement or somewhat implied in conduct, et cetera, et cetera. And there's many, many cases of that. So really, to have a legally binding contract, it's just these 4 elements. And to just bring them to life, I've got a simple example at the bottom. Alex offers to sell a car to Taylor for $10,000. Taylor accepts the offer, and given the value of the transaction, and the parties are evidently intending to create a legally binding agreement. Now here we've got the offer, which is Alex, named after me, offering to sell the car. We have Taylor, who is accepting the offer, named after our AI tool that we just released, which is called Taylor AI. Although interestingly, there's probably a theoretical legal question as to whether an AI can accept an agreement, but let's not go down that tangent. Imagine it's a person called Taylor. They're accepting. The consideration is that $10,000. And then we have the intention to create legal relations, which, so this is an interesting one because you never really know what's in the mind of the people making the arrangement, particularly if it's not in writing. In this context, if there was something in writing, you might use that to infer that there was an intention to create legal relations. If there isn't, you might just have to infer it from the value of the transaction, but it's something that could be argued if Taylor, for example, wanted to pull out of the deal. Taylor could say, oh, no, I never intended to create legal relations. We were just chatting about it, et cetera, et cetera. So these are the kind of elements that we're looking for in a contract. So even from that example and just that little bit of additional context right at the end, there isn't a requirement to get a contract in writing, but it is a really good idea to get it in writing in many, many cases. And part of it is to give it clarity and certainty. How do we know that there was what the offer was? How do we know what the amount of consideration was? How do we know about this intention to create legal relations and whether it was present? If we all are agreeing things orally or over messy emails and so on, it can be very difficult to distill what the actual contract is and whether it even exists. Whereas when you have a formal written arrangement, we're now able to say, okay, this has clearly got the elements of offer, acceptance, consideration. It's written and it's signed. It's clearly intended to be legal. So the parties are agreeing to be bound on these terms. And we really get clarity about what the deal is, what the arrangement is. And that's why lawyers are always saying, get it in writing, because it's really important to make sure that, if you want to bind people by certain terms and conditions in relation to arrangement, that is clear as what they are. And again, if there is a dispute, if something goes wrong, somebody suffers loss, somebody's unhappy, and there's plenty of scenarios in business where this could happen. It could be your employees, it could be your suppliers, it could be your customers, it could be your business partner. This written arrangement is going to be the source of truth in terms of how the dispute may play out and who's liable for what. Because again, the terms can specify what the offer was, what the acceptance was, and what each party was kind of doing for each other. Now, of course, you can see that not only do you want a written contract, you want a well-written contract, because otherwise you're not necessarily going to have good clarity, good certainty, and proof of agreement. But this is kind of why this writing element matters. Another reason why a lot of people do contracts, particularly with customers or suppliers, is just professionalism. It is possible to do business without contracts. You can, when you go to the cafe and order a coffee, you don't sign a contract for $3 to get your cappuccino. So you don't need them for every transaction. But in certain business transactions, it can add to the professionalism, add to this, in part by adding that clarity and certainty. And so for a lot of consultants that engage Sprintlaw, a big reason why they want the agreement is because it helps them look professional in the way that they conduct their business, and it really is the first point of marketing their own skills. So that's one reason as well to consider having something in writing. Again, the more complicated the arrangement is that you're doing with someone, the more important it is to get it in writing. With this car scenario, it's fairly straightforward. It's just an offer to buy a car for $10,000. We probably know what the car is. We know what the amount is. But if this arrangement was more complicated, the car was being paid for in installments. If there was a problem in the first 6 months, Alex could get a 50% refund. If it got more and more sophisticated, that becomes more and more important to get something in writing to explain, I guess, how it all works. And finally, I did say earlier, there's no legal requirement for a contract to be in writing. Now that's mostly true. In general, it's true, but there are specific types of contracts that the law specifically says do need to be in writing. For example, the contract for the sale of land, certain types of leases, certain types of credit agreements actually by law need to be recorded in writing. So that's another reason why people are getting these written contracts sort of put together. Um, so just coming to when is a written contract most important? So, as I said, when you're ordering a coffee, you don't sign an agreement. And in practice, most of you, if you've been involved in business, would have made arrangements without contracts before. And you would have also signed contracts before or signed up to contracts before. So a question you want to be asking yourself is, when do I actually want to have a written contract in place? When should I be making a fuss about this? And I've shown this in many of the presentations I do. I think really for a lot of legal questions, thinking about things in terms of a risk matrix is a really good way to approach, how legal you should go about a particular issue or topic. If you're doing an incredibly important deal where if things go wrong, it can have massive consequences, and you think those things going wrong is a real possibility of happening, you really want to be getting a contract in writing in place to reduce those risks. Things like your business partner or shareholders agreement that are critical to the operation of your organization or your company. Those are the kind of like really important documents that you might want to have in writing. If you're buying, I don't know, a couple of pieces of equipment, secondhand from somebody, maybe then. It's not a big risk if the equipment doesn't work, and it might fall in the yellow or green areas on this chart. So, and everything sits somewhere in that spectrum. But when you're a very small business, you're going to make sure you've got the red areas covered. You're going to make sure you've got contracts for that stuff. As you get a little bigger and can afford to have some more comprehensive risk protections, you might push through to the orange areas. And then large organizations are doing the yellows and greens, and they'll be getting things in writing for most arrangements that they have. So that's how you might think of it in terms of your budget and scale. No one has money to get every single contract they've ever signed in business reviewed and checked by a lawyer or every arrangement in writing. But certainly, if you need to focus your time, think about how big a risk does this pose for my business. So now let's dive into some key contract concepts. We're going to be looking at written agreements. And if you're handed a written agreement, there's a lot of text that you're presented with. Or even if you read terms and conditions on a website, there's a lot of text that you're presented with. And I still remember when I first started as a graduate lawyer at one of the big firms, the first task I was given was to read a business sale agreement or proofread a business sale agreement that had been drafted by one of the senior lawyers just to make sure it was all okay. And I'd never really read a contract before, except a little bit at university. I printed it out, I took it home, and I remember sitting on my couch trying to read this 40-page document, and it was just so boring, and I had no idea what was going on, and it was completely incomprehensible. And I'm like, how am I going to get through 40 pages of fine print? I eventually did, and as I read more and more, I started to realize these documents, they're not quite like novels or books where every word is telling a story or painting a picture of what's going on. They're structured documents. They're divided into sections. And if you are handed a contract and you can break them down into bits and pieces, it becomes a lot easier to read and understand these documents. And certainly you learn over time that there are these core elements, which we'll go through now. And then even within each of the elements, there's kind of conventional ways that agreements are structured. These days when I read a 50-page agreement, I can do it very, very quickly. I know where to flick to. I know where to look for things, and I'm really much more able to decipher the fine print. And so again, people here don't necessarily have to be at a lawyer level with the agreements, but it is useful to understand how these things work and how you might break them down if you give them one. So just going through some of the concepts, and some of these are fairly basic. When you're handed an agreement, typically there's a section called the parties section. And that's going to identify who is the offerer, who's the acceptor, or at least who are the two people making offers and acceptances to each other. What's their name? If they're a business, what's their ABN? What's their address? And that looks kind of like what we have on the left of screen. There's often also a definition section, and it's convention inside written agreements to rather than writing out a concept in great detail every single time to explain how it means, to create a little shorthand version of it. So you can see I've got, as an example, a a clause from an agreement. The client may terminate this agreement for convenience at any time by providing 20 capital B business capital D days written notice to the service provider. And then there's a definitions section in this agreement. And the way the definitions work is somewhere in the agreement it says capitalized terms have the meaning given to them in the definitions section. So anytime we're using these big B's and these big D's, we need to flick to the definition section and look, what does that big B, big D business days mean? And we can see here that a business day means a day that is not a Saturday, Sunday, or any other day, which is a public holiday or a bank holiday in the place where an act is to be performed or a payment is to be made. So every time the word capital B business days is used in this agreement, it actually has this meaning set out in the definition section. And you can see, if you just cast your eyes down, that this definition section is actually quite important, and it's used to define all kinds of terms that are used throughout the agreement. So confidential information, which is no doubt probably used a lot in the agreement this is taken from, has a very long definition. So every time that term's used, this kind of defines what it means. And so again, when you're reading an agreement and it's saying all kinds of things, and you're like, well, why are these random letters capitalized? It actually has a whole lot more meaning than you're reading in the clause, and you need to flick to the definition to understand what it means. And a lot of agreements will look nice and pretty on their surface, but if you actually go read the definition, maybe something sneaky's in there, and maybe the way that business day is defined doesn't exclude public holidays, and so when you thought you had 10 days to do something, it's actually but you thought public holidays would be excluded. They're not, and you need to keep that in mind whenever a public holiday occurs. So those are the sorts of little things that you find out in the definition section. We've then got the terms section. This is the big meaty section of the document and what most people think of when they're talking about a contract. And usually there's tons and tons of clauses in here, and we'll go through this in a bit more detail in a couple of slides' time. But the terms section sets out what the actual terms and conditions are for this agreement. So we know who the parties are. We've got these defined terms set up. What's each person doing? When does this thing start and finish? What happens if things go wrong? How does payment work, et cetera, et cetera? All the kind of details of the arrangement are contained in the body or the terms section of the agreement. And then sometimes we have these things called schedules, which sit at the back of the agreement. And particularly if there's like price lists or detailed scopes of work, or kind of important commercial details to the agreement, you could put them in the terms section, but then they'd be buried in with all the different fine print and difficult to extract. So it's common practice to set up these schedules where it's easy to read. A business owner can flick to the schedule to understand what the pricing is without having to decipher the fine print of a particular clause. And for example, if you have a standard agreement and you need to tweak it and edit it for multiple people, you can just be changing the schedules and little tables instead of having to change little paragraphs in an agreement. So you often see these almost, sometimes they're called attachments, sometimes they're called annexures, often they're called schedules or schedules, and this is kind of what they look like. And then finally, you have your signatures section or element of a contract. And typically in a formal written agreement, there is a place for the parties to sign. They can enter their name. They can enter their signature. We have in the bottom left corner the formal way that a company, a PTY Ltd company, is meant to sign an agreement, where the directors of the company actually sign the document. This doesn't have to be used for a company to be bound to an agreement. It can be signed using one of the more informal blocks above it. But in really important agreements, people will insist that you use that more formal signature block, because there's certain laws that say if you get it signed, if you get a company document signed using that bottom left corner signature block, the company is strongly bound by the arrangement and can't in future claim that they didn't know what they were signing or that someone signed it without their approval. Whereas if an informal signature block's used, it's possible for the company to later on claim, oh, my employee just signed that and I never authorized them to sign it, and that's not a real agreement. And so again, banks or investors prefer to use the bottom left corner signature block in really important arrangements, but maybe not in less important ones. And now we have on the right other forms of acceptance. Again, as I've said from the beginning of this presentation, there is no legal requirement that contracts are in writing, and therefore there is certainly no legal requirement, with maybe some exceptions to in specific areas of law like property transactions, but in general, no legal requirement that contracts are signed using, a scribbly signature and so on. And it is common practice, particularly in digital business, to not use a formal signature block because things aren't being printed on paper. Although of course we have, DocuSign, and even Sprintlaw now has our own DocuSign as a tool where people are doing signatures digitally. But many businesses use tick box to accept, and in the legal world we call these tick boxes click wrap agreements. They're a kind of evolution of a term from the 80s and 90s called shrink wrap agreements, where people would receive CD-ROMs of software, and the packaging would say, by opening this shrink wrap, you agree to the contract related to this software. And it was a kind of innovation in contracts to enable software businesses to get things accepted en masse. And again, the click wrap agreement is an evolution of that online. So, everyone here would have ticked a box like this: I accept terms and conditions. And there's good law to suggest that when you tick that box, you are signing in effect a contract, and the terms and conditions of which is hyperlinked there. Now, there's some laws where if sneaky things are hidden in the terms and conditions, it can be considered misleading, et cetera, et cetera. But in general terms, there is an equivalence between this kind of formal written contract with parties, definitions, terms, schedules, signatures, and a tick box with the terms and conditions that will often be structured, again, with the definition, terms section, maybe even schedules, and sometimes parties will be, contained in a contact form rather than in the agreement format. But again, in essence, we still have ourselves a written contract with these click wrap agreements. So whenever you're signing up to softwares or logging into Instagram or whatever it is, you have a contract with the platform or the vendor in these included in these terms and conditions. Now, in the bottom right corner, we have a kind of slightly dodgier way that people try to get people to sign up to contracts. And these are what we call browse wrap agreements. And they say, by using this website, you have accepted our terms and conditions. So just by going to, sprintlaw.com.au, you are hereby bound by our terms and conditions, and, you're signing the contract. These are a little grayer under the law because it's potentially difficult to prove these elements of offer, acceptance, consideration, and intention to create legal relations, particularly if when someone came to the website, they didn't even see your tiny little terms and conditions. And so you don't have these elements of offer and acceptance of your terms. The consideration, may not be there. I guess they're using your website in exchange for accepting the terms. But is there an intention to create legal relations when they just see your website? Unclear. So these are still commonly used. Certainly on Sprintlaw's website, we have a browser app agreement just for our web terms, and we link to it in various places. But whether they can be enforced is a little bit grey. And definitely, if you're wanting to put a contract in writing, using this kind of just by using this website or our services you accept is a little bit risky because you may not have those elements to form a binding contract if you need to enforce it. So in general, when people are asking us, how do I make it really easy for my clients to sign my agreement, best case is get them to sign a signature block. That's super certain. The opt-in click wrap is also pretty good as well. Not quite as strong as the signatures. You may not have clear evidence as to when they tick the box, what time they tick the box, who actually ticked the box. So it can be challenged, but there's good law to suggest that it works as well. And then these kinds of, I've sent you a copy of my terms hidden, buried at the bottom of my website, and just by talking to me, you accept them. Those are probably the most risky case of getting a contract sort of signed. So hopefully that is all making sense. Now I'll just quickly flick to contract structures. So how do you put all of these different elements together? I just talked about parties. I talked about terms, definitions, signatures, schedules. The answer is there's no one way to assemble an agreement. But when you look at a document, there's conventions in terms of where all these things live in a contract. So in most cases, in a kind of formal written agreement, the first thing you see is the parties right at the top. Of course, if it's just one of those website terms and conditions, there might not be a party section. It might be somewhere else. It might be on the kind of form that you're filling out. You'll then typically have your definition section either next at the top of the agreement or sometimes at the bottom of the agreement. So if you're trying to flick to the definitions in an agreement you've been given, you might find that at the front, you might find that at the bottom. You've usually got the terms in a fairly prominent place. Like I said, that's the body of the agreement. That's got all of the different actual obligations in it. And then the schedules are usually at the back and the signatures are usually at the bottom. Although you often see, particularly for standard agreements, if you're running a services business, for example, and you're sending out quotes and scopes to people, you might have what we call an order form, which is almost like a schedule that you chuck on the cover page that just sets out, the prices and the key details of what you're doing. And you might put the signature right under that. And then you might have the whole terms and conditions attached after the signatures, almost like a schedule, and the definitions right at the kind of back of the arrangement. So all of these work. It doesn't have to be in any particular format, but this is just common ways. And again, like I said, first time I read a contract, it was all gibberish. It was a long narrative to me. But now when I'm given a contract, I'm like, okay, where's the parties? Where's the definitions? Where's the terms? Where's the signatures? And I can break it all up and actually read it. And I might just quickly flick to an example of an agreement, which is a supply agreement, which hopefully people can see on screen here. And again, you can see here, it's got the party section first. Then as we scroll down, we've got our big terms and conditions section. You can see all these defined terms throughout the agreement. And then we've got the definitions at the end, and there's a sentence in here that talks about capitalized terms have the meaning given to them in the definition section. And then we have the signature blocks that look like this, and then we have at the back our schedules. And so again, if I'm reading this agreement, the first thing I'm going to kind of look at is, okay, it's a supply agreement. I might actually flick right to the end and go, what are we actually paying here? Okay, interesting. And then I might start looking through the terms and conditions, and I'll go through that in a bit more detail in a moment. And then, be checking definitions as I go through and kind of working to understand the arrangement. Just notice we had a question here. What if there was a contract that expired but the services continue? Is it still legally binding in the case of a dispute? Recently, we had a case where services were provided after the contract expired, the same type of services as during the contract, and the client refused to pay, claiming the contract expired. I mean, that's a very common case that we get asked about, and the answer is never really straightforward. It kind of depends on how the contract is drafted. We often write in fixed term agreements for our clients a clause that says if the services continue beyond expiry, the same terms and conditions will continue to apply to any services, but there's no obligation for them to continue, and that makes it quite certain as to what happened. If there is no sentence like that, it becomes contestable, and you're in one of those situations where you don't have a clear written agreement as to what happens, and people can make arguments either way. And again, to advise on your specific case, we'd have to look at the situation, but one argument that could often be made is, well, you accepted the services and clearly you didn't think they were free, and clearly we already had an agreement in place, and so you've accepted them, you were aware there was some consideration, and so you're still liable to pay. And there's various other arguments under various other kinds of laws of unjust enrichment and otherwise that can be argued in those kind of cases where the contract expires. But of course, it's always best to stay on top of the agreements and try and avoid those scenarios. So, I mean, if you need advice on a situation, do feel free to reach out to our team and we can provide some assistance on it. But that gives you a flavor for how we think about those kind of scenarios. So we talked a lot about the different high-level elements of an agreement. But as I mentioned, all of the details are contained in the terms section of these agreements. So, this bit here, when we break it out. Now, inside the terms section, it's got its own structure. And again, as you become a contract lawyer, what we get really good at is looking at a terms section and we also spot patterns in the way these things are assembled. And again, there's no law as to what order the clauses need to be in, the terms need to be in. It can really be structured in any order, but there's a conventional way that things are organized. And certainly lawyers learn, for example, that duration, how long there's agreement for, is kind of up the top, terminations down the bottom. Kind of makes intuitive sense. Generic stuff is at the very, very end. IP is usually in the back section. What people are doing is usually in the top section, and so on. So different agreements have different structures. So I got 3 examples on here. I've got a service agreement, which begins with the duration, then sets out what each party's doing. Then it covers payment and invoicing. Towards the end, we've got IP, liability, termination, and then we have what lawyers call boilerplate clauses, or just generic clauses that are formal things that help make the overall agreement enforceable. It says, the wording in here will be interpreted under Australian law. If someone needs to tell someone something in any of these other clauses, here's the email address they use. If people want to change the deal, they've got to sign something else in writing. If there was any discussions before, this contract supersedes them. So a lot of that's in the boilerplate section, but the concepts themselves, will be set out in these different clauses. And then you can see in an employment agreement, very different type of agreement, loosely the same structure though. We start with the duration. In the service agreement, we're talking about what the client and service provider are doing. In an employment agreement, we're talking about the employee's duties. Rather than payment and invoicing, we're talking about salary and entitlements. Here we've got non-competes, which are maybe specific to employment agreements, and then IP is towards the back, terminations at the end. Then we've got the boilerplates, and then a very, very different type of agreement, which is like a shareholders agreement between business partners, has its own structure, decision-making, how a decision's made up the top, some clauses around rights of first refusal if someone wants to leave, or what happens if someone leaves early, and similar kind of restraints, non-competes are towards the middle, IP, confidentiality at the back, and then termination you see in all these examples is towards the end. If there's a dispute possibility, dispute resolution clauses are often towards the end, and then we got the boilerplates there as well. So when you're handed these agreements, again, you got this big document. First thing you're going to do is break it down into the different constituent sections, and then you're going to be looking through the terms, knowing that probably the terminations towards the back, the durations towards the front, and some of these other clauses are kind of towards the middle section. And again, just to bring it back to the example I was looking at earlier, this is a supply agreement. At the beginning, it has the term. It's then got payment towards the middle. It's got liability stuff, warranties is what it's called in this agreement, towards the later section, and then it's got termination towards the end, and then it's got these boilerplate notices governing law clauses right at the back, and then it's got its definition section and schedule. So you can see how that kind of plays out in a real agreement kind of in practice. So now let's talk about red flags and what to look out for when you're handed any type of agreement. And I'm going to go through a few different common clauses you see in agreements. But before I go through them, I've got a public service announcement, which is, I think, something that is really, really important and not understood by people in business, which is that whether a contract is good or bad really depends heavily on who you are. If you are a service provider and you have a service agreement, that agreement could be terrible for you and amazing for your clients, or it could be amazing for you and terrible for your clients. Now, usually, if you're the service provider, you want the latter case, the one that's amazing for you and terrible for your clients. And if you're the client, you want the opposite. One of the biggest challenges or problems that we see, or mistakes that we see businesses make, and I actually analyzed last year, I went through, I think, all of the 10,000 legal matters we'd done to find the biggest mistakes that our clients have made that we kind of had to fix up. Not registering trademarks is number one, but number two was using like a template, an online template of a contract, which they'd gotten off, some template website online, which was designed for the opposing party, and they didn't realize it. And they actually arguably would have been better off with no agreement, because they might be a service provider and they were using a customer-friendly service agreement, which was not a bad document, but absolutely terrible for them. They were promising all kinds of things they didn't have to, giving themselves way more liability than they needed to. So it's really, really important to keep in mind when you're reading an agreement, who am I in here and what do I care about? And is this agreement or document serving me, my purposes, or is it serving the other party's purposes? very, very likely if someone else has given you a contract, it serves their purposes because it's their contract. And so it's good for them, and they're not often thinking about what's good for you. So often when lawyers are reviewing agreements, we're thinking, okay, well, this is probably good for the other party. Let me have a look in here and see what are the things that are really a bit ridiculous, or what are the things that we really care about, that my client really cares about, and can we ask to have them changed in this document, or negotiate them, or at least advise them not to sign it because it's got these problems. So keep that in mind. And again, we're going to go through different clauses, but I'm not going to say whether a clause is bad or good. I'll say it's bad for client, and which implicitly means it's good for service provider. And again, you can see I've got the service agreement structure. In each of the different clauses or terms, you can see a broad scope in a service agreement. The service provider will do anything that the client asks. Is really great for the client, but terrible for the service provider because they've got no way where they can say, well, this is out of scope, this is too much. So the same clause, different effect. Fast payment, anytime an invoice is issued, it must be paid within 2 days. Very bad for the client. They might not have the cash to stump it up that quickly, but good for the service provider. IP, who's going to own any IP or original work that's created? The client might want to own whatever the service provider does. That's good for the client, but that might be bad for the service provider if they want to reuse some work they've done for a client for another client. Liability, if something goes wrong, can we sue each other? Again, something that's if the liability is limited to a refund, so the worst that if the service provider really messes everything up, the worst case scenario for them is that the client can only get a refund of their fees, even if the service provider ruins the client's business. That kind of limitation might be bad for the client, but quite good for the service provider. And finally, termination. Canceling any time, great for the client. Lock-in contracts might be better for the service provider. So I'll go through these in a bit more detail with some changes in wording, but you get the idea here that really whether it's good or bad, or whether it's a red flag, depends on sort of who you are when you're reading the clause. So let's go through some of these specific examples. So I'll start with a payment term. And a lot of these come from kind of service goods customer agreements. This is probably one of the most common agreements that we see, rather than like employment agreements or other sorts of agreements. So again, you'll be seeing these in agreements that suppliers or service providers ask you to sign, or maybe in your own agreements you have with your clients, you'll have clauses like this. And I'm going to give some fairly extreme examples, and the answer is often a compromise somewhere in between. But let's look at this one versus a payment term. So this is an example of a payment term that's really bad for a client, but not bad for a service provider. And it says the client agrees to pay the full amount upfront with deliverables to be provided at the provider's discretion. So this is a fairly obvious example. A service provider is going to promise to do something for you, but they want 100% upfront. You don't know if they're going to do any good job. You've got nothing, no leverage if they do a poor job. They've taken your money, so it's quite risky for the client. And some of the specific wording here, it says deliverables to be provided as per the provider's discretion. It doesn't even tell you when you're getting the deliverables, what quality they're going to be, and if they're terrible, there's nothing in the agreements that says you've got any rights to claim. And again, you got that financial risk with the upfront payment, and not much accountability really for the service provider. So an alternative version of this clause that would be better. And again, if a lawyer read that, they would suggest to the client, hey, they're asking you to pay 100% upfront. That seems risky. Why don't you split it 50-50 and maybe have a little bit more detail on what you're actually getting? So in this updated clause, the client agrees to pay 50% upfront with the remaining balance due upon delivery of all agreed capital D deliverables. And you can see there's a capital D deliverables, and I haven't got it here, but you might then have a schedule that explains exactly what they're doing. And that list of exactly what they're doing with the capital D deliverables needs to be ticked off for them to get that remaining 50-50. So again, you can see that negotiation is much better for the client because they don't take all the risk up front. Of course, even better for the client would be to pay 0% upfront. But oftentimes you've got to find a balance with these clauses that's reasonable for both parties, because then it puts a lot of risk on the provider. So this version is like a balanced version where it's 50-50. We've got a clear definition of what's going to happen, and it's ultimately going to be a lot better an outcome for the client. Now we've got an example of scope wording. So this is a very, very common problem that we see where someone quotes a client for something and it's discussed orally kind of what they're going to do or over email, but the actual definition of what's included is really not set out in the agreement. So this says the provider will deliver services as necessary to fulfill the project requirements. So this is really, really vague. It's actually bad for both parties, not just the client, to be this vague, I would argue. Even though the provider has some discretion to say that things are done, the client could really argue that this has an unending scope as well. So if you go back to that early slide, I talked a lot about the point of a written contract is to have really this clarity and certainty. Well, if you have these poorly drafted agreements that don't specify what you're getting for what you pay, you're not really achieving that first goal of a written agreement, which is that you have clarity and certainty. This really gives you no clarity and certainty as to what the services are, what the project requirements are, when they're going to be delivered, et cetera, et cetera. So an alternative version of this clause is the provider will deliver the services as outlined in Schedule A within the agreed project scope and timeline. So it's a lot more certain as to when things are going to be done, what's going to be delivered. It doesn't have that unending scope. And for those of you that have engaged us as clients, you'll note that we do this as well. We have scopes of work. We send out quotes. We'll send different line items. And I've just put a screenshot from one of our services, Register a Company. And it's cut off a little. There's actually more detail to the scope. But in essence, what we say is quite clear. Like, you're buying our Register a Company service for this fixed price of a few $100s. You're going to get 60 minutes phone or video with one of our lawyers. We're going to apply for this ACM registration, apply for this ABM registration, and we're going to deliver these 7 documents to you. And so it's pretty clear as day what you're getting for your money. And if things go beyond that scope, we would have the right, if we wanted to potentially give you an additional quote. And it's super clear. And again, at the time of payment, clients know what they're paying for. They can look at the scope. So it really reduces the risk of misunderstanding. Again, a lot of the reason for getting clear written agreements is not because you might expect to sue each other, sue your clients, but it actually just makes for a much better client experience because at the beginning they know what they're paying for, they know what value they're getting for their money, and when you deliver what you said you'd deliver as a service provider, or even you deliver a bit more than what you said you'd deliver, you're really helping meet their expectations and exceed them because you've set them very clearly. It's when you don't set expectations or when things are really vaguely worded that you have these poor experiences. So we spend a lot of time just at Sprintlaw. We have many, many different types of services. We spend a lot of time on our scopes, and certainly in the early years we had scopes that we thought were tight, but then issues happened. And we realized we needed to add an extra bullet point, or we needed to put a time limit on things, or we needed to specify more clearly what was being delivered. And the more that we did that, the tighter our operation became, the better experience it was for both parties, and ultimately, the more profitable everything became for us because we were super clear about what was being done. So really, this isn't just a kind of amorphous legal risk thing. It is super important to write these scopes clearly, and it's a very common issue that you'll see in agreements, whether you're the service provider that's providing something or whether you're a client that's paying for something with a vague scope. I would spend a bunch of time thinking about this. Let's now talk about IP ownership. I've done kind of separate presentations on what intellectual property is, but as a 10-second crash course, this refers to kind of original works that are recorded in material form that might be created in the course of your business, or at least that's what we care about here. So, for example, if someone's writing, making graphic designs for you, or designing websites, so they're doing artistic work, so they're making music or written work or software code, any of these stuff, if it's original and it's kind of unique, it's potentially ownable, and by default, the intellectual property, when created, is owned by the person that created it. So if your employee does something original for your business, the default position is that the employee actually personally owns it. And this is why employment agreements are really important, because they have a clause in there IP ownership that says any work that you do while you're an employee that you create, you'll immediately upon creation, you agree gets transferred to us. And that wording in the contract means that the employee only actually owns it for a split second before it just by law gets transferred to the company. And the same thing goes with your service providers. If you don't have a contract with them and they're creating stuff for your business, as I said, website code, designs, even strategy documents if they're original and so on, these kinds of things are default theirs. And unless you got a document that makes it clear that you own it. And it gets even messier because what if you collaborate with a supplier and together you create something novel? Maybe it's a design, maybe it's a new product, or maybe it is a new strategy document, design, whatever it is. You create something original. Even worse, by default, if there was no contract, you might both own a little bit of it. But if the contract says the wrong thing, you, the client, might actually have no rights over it. So in this example, we have wording which is very bad for the client. It says all services and deliverables developed during the term shall be owned by the provider, and nothing in this agreement shall transfer any intellectual property rights to the client. So this means that you've engaged a service provider as a client to do something for you. You've paid the money, but anything they created that's original is actually theirs, even if you contributed to it. That's what this says. Now, if you're a service provider, this is actually not bad. It's a pretty good clause because it means, which many service providers want to do, that they can do stuff for client A, then pick it apart and reuse it for client B. So again, if you're a service provider, you might want this to be your default position. But if you're a client, depending on what it is, you might not like this. So a common compromise that we see on the intellectual property clause is something like this clause. All intellectual property created specifically for the client of this agreement shall be owned by the client, but the provider retains ownership of pre-existing IP used in creating the deliverables. So the way this works is the client's going to own new stuff that was created in collaboration with the service provider, but any stuff that the provider already had before they even started working with the client, which they're probably using already or want to use with other existing clients, that stuff will be retained by the service provider. And that's often a fair compromise. New stuff I make with you is yours, but stuff I already had is mine. And of course, you see here we've got the capital I, the capital P for intellectual property, and the capital P and E for pre-existing IP, because in each case, we need to be pretty clear if we can about what is the pre-existing IP, what was owned before, and what is this intellectual property that might be developed. So those concepts become really quite important. Just turning now to renewals and termination clauses. So one of the things I remember very clearly when I had just started as a lawyer, one of the senior commercial contract partners at the law firm I was at, was doing a kind of coaching session for me on how to read commercial contracts, and he said to me, "What do you think the most important clause of a contract is?" And I said, "That's a broad question. I have no idea." And he said, "Think about it." And I said, I still have no idea. He said, "Look, it's a bit simplistic, but one way to think about it is the most important clause of a contract is the termination clause." He said, because if you're going to get someone to sign something, you need to know how they're going to get out of it if they regret it, and what the cost of getting out of it if they regret it is. And so he said, if you're given a contract and you've got 10 seconds to look at it, he's like, the first thing you want to look at is that termination clause. And if that's all you look at, then so be it. And again, that's very simplistic, but it is, I think, enlivens you to the importance of these termination clauses. When you sign something, how can you get out of it? Is this a decision that you can walk back from, or are you really committing to something that you're going to regret? So do spend time looking at these termination clauses whenever you sign something. Is it a 1 year lock-in? Is it a 10-year lock-in? Can I just quit after 3 days, 30 days? What are the consequences or costs of doing so? And if it's a longer period lock-in, I think you're going to find that you classify this in the top, closer to the top right corner, because it's a higher risk agreement than if it's a thing you can terminate 2 days later. It's probably in the yellow or green sections. So here we've got an example of a termination clause, which is not great for the client. This contract will automatically renew for an additional year unless either party provides 90 days written notice before the expiration date. So This is a contract that needs 3 months notice, which is quite a long time. Often 3 months before an arrangement is ending, people may not be thinking about the arrangement ending. Now, if it's a 20-year contract, maybe fine. 90 days is actually quite short in the scheme of things. But if it's a 1-year contract, 3 months is, a big component. It's like a quarter of the contract that you got to be thinking about in advance as to whether you're going to renew it or not. And if you don't provide notice in that 90-day period, it's going to get automatically renewed for another year, right? So this is a bit of a trap that you can see here where a service provider might be able to lock in a client for multiple years by having this long notice period and an automatic renewal clause. It doesn't look like a very scary clause, but if you actually think about how it works, it's a little bit of a red flag. So maybe a more common compromise for these annual agreements might be to say this contract may be renewed annually by mutual agreement of both parties. So it's not automatic. We've got to have a discussion and decide that we want to agree. And, either party may terminate with 30 days notice prior to renewal. So it's not even locked in for the whole year, but you can actually, with a month's notice, exit at any time. So obviously much better for the client. They're not locked in for the full year. They're only locked in for 30 days at any one time, and they're not tricked into automatic renewals, if that makes sense. So yeah, that's one way to think about these renewal and termination clauses. Now, just onto the kind of final clause I wanted to talk a little bit about is the liability clauses. These are kind of technical clauses, but I would argue these are if the termination is the number one most important clause in the agreement, the liability clause is probably the number two most important clause in the agreement. Because the liability clause, if it's drafted into the agreement, which it isn't always there, sets out how liable either party is if things go wrong. And so I've been talking a lot about from the client's perspective, but this one I'm looking at from the service provider's perspective. If you're providing a service to someone and something goes wrong, ideally for you as a service provider will be not necessarily liable for all the consequences of the things that go wrong. If you are like a website developer and you make a website for a client and then the website breaks and the client loses $1 million for whatever reason because it broke for a long period of time, but you're just a small web design business, you don't want to be on the hook for that $1 million that they lost. So you're typically going to be wanting to protect yourself and limit your liability. Maybe you'll agree to fix it for free. Maybe you'll agree to a refund if it's really bad. Maybe you'll even agree to 2 times a refund if it's really, really bad. But you might not want to agree to what we call unlimited liability, which is no cap on your liability if things go wrong. Or even more aggressive than that is something that we call an indemnity, which says not only can you sue me for anything, I specifically agree I'll cover any dollar that you suffer from any loss, without you even having to go to court to necessarily prove that I should be liable. An indemnity is very much like an insurance policy. So it basically says I, the service provider, agree to insure you for any risks that happen from my services or deliverables. So these clauses, these indemnities and liabilities can be very, very risky for service providers. And typically, if you're a small business service provider, you don't want to give any indemnities if you can avoid it. And you want to ideally limit your liability by some amount to, in the best case, just a refund. But if you have to, maybe you'll agree to a couple of times on the refund. So this clause is really, really bad for a service provider. It says a provider agrees to indemnify the client for any and all claims, damages, or loss arising from the use of services or deliverables. So again, if we use a web development example, I make a website for you, something goes wrong in relation to the website. Now I've got to be your insurer for any issue whatsoever arising from the service or deliverables. Super broad, big unlimited liability, and very one-sided. And great for the client. They can go back to the web developer and get mad at them anytime something goes wrong and not have to pay any more, and try and sue them if there's a big issue. But for the actual provider, it's super risky. So what we would generally suggest a service provider do is try and negotiate that. So I'll just start with the second paragraph. Best case, the service provider will say, I'll give you a refund if something goes wrong. More common, they might offer a bit more. So a common clause you see is the maximum liability of either party under this agreement will be limited to an amount equal to the fees paid by the client to the service provider in the last 6 months under this agreement. So, will refund you up to a maximum of the last 6 months fees, and that's only if you really suffer big losses. So that's much better than this, which has a completely unlimited liability. So that's much better for the service provider, but maybe not that reasonable for the client, because the client's like, look, I'm paying you for a very risky thing, and you're going to get access as a web developer to, when you're preparing this, my confidential information. And what if you do dodgy stuff, like you're tracking my clients, like personal information and selling it to third parties, and I didn't even know you were doing that on my website, and I get fined because you did dodgy stuff. There are scenarios where either client actually, I don't think this 6-month cap is reasonable because you did something so bad. So sometimes you see a compromise where there's a general cap for that 6-month period or a refund or whatever it is, but for really serious things that the service provider does, we go back to that unlimited liability or even sometimes that indemnity. And that's often where you see a compromise happen around these liability clauses. You say, look, we'll allow you, the service provider, to have a cap, but if you do something really, really bad, like breach our confidentiality or steal our IP or break the law or commit fraud or injure somebody, we're not going to let you be capped, and we're really going to come after you for that. And that's often seen as a fair compromise. And if you're a service provider, you might have to agree to that depending on what your business is. You'd prefer not to, but you might have to. And then you're going to want to probably take out your own insurance policy to make sure that in the worst case scenarios where you are liable, you've got an insurer that can kind of protect you from that kind of risk. So back now to our little matrix. As you can see, this stuff gets a little technical, and by no means do I think people should try and get to a level where they can read contracts as well as a contract lawyer that does it every single day. But you do want to know, you're going to get a lot of contracts from suppliers, from software vendors, and you do want to know, when should I bother getting this checked, and does this look bad? So it is worth having a working knowledge of how these clauses work, maybe looking out for some of the ones I flagged today: termination issues, payment issues, liability issues, and being able to just break down the agreement, read them, and flag whether there are issues. And think about also getting it checked by a lawyer when it's really important. And again, I encourage you, you're going to get so many contracts, to think about how important is this, how big a risk is it, what's the value of this thing, can I get out of it, et cetera, and place it on this matrix. And when you're hitting those orange and red sections, do think about reaching out to a lawyer. We not only can help you with risk management, when we help you with things like scope and payment terms and so on, we actually can help you make a better deal that makes you more money or improves the profit as well. So yes, definitely do think about all those different aspects. So that was all I wanted to cover for today. Thanks so much for listening. I think we're about at time, but I hope people enjoyed this presentation, and do feel free to take advantage of the Black Friday thing. If you just head to our website and sign up to a free account on our platform, it's right there, or you can use one of these codes. And otherwise, we do these every month. So for those interested in coming along again, look forward to seeing you then. All the best.